5 seconds to go. Start. The question may also be examined from a different angle. Section 24 of the 2013 Act expressly refers to the land acquisition proceedings initiated under the LA Act. Subsection 1 of Section 24 of the 2013 Act is as under. Land acquisition process under Act number 1 of 1984 shall be deemed to have lapsed in certain cases. Notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply, or where an award under said Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act as if the said Act has not been repealed. Notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act 1894, 1 of 1894, where an award under the said Section 11 has been 5 years or more prior to the commencement of this Act, but the physical possession of the land has not been taken, or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this Act, provided that where an award has been made and compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under Section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this Act. The 2013 Act repeals only the LA Act and not any other central or state enactment dealing with acquisition. Therefore, what is sought to be saved under Section 24 of the 2013 Act is only acquisitions which had been initiated under the LA Act, and not those acquisitions which had been initiated under any other central or state enactment. The expression contained in Section 24 of the LA Act cannot be given extensive interpretation by adding words into the provision in the absence of the provision itself giving rise to any such implication. We are of the view that 2013 Act would not regulate the acquisition proceedings made under the BDA Act. Section 105 of the 2013 Act states that the provisions of the 2013 Act shall not apply to the enactments in the 4th schedule or are to apply with modifications in terms of notification issued by the central government under Section 105(3) of the 2013 Act. Section 105 does not apply to the present case. Recently, a division bench of the Karnataka High Court in Shri L. Rama Reddy versus the state of Karnataka and others has considered identical questions in great detail and has concluded as under. Stop.